Good day, my name is Warren and I am from PropWiz. Today I will be sharing some information from our website with you. This will be with regards to understanding electronic signatures in the South African real estate market. All of the discussions we'll have on this channel you can find on our website. If you go to www.propwiz.co.za and you can go under the tools bar and then select latest news. As discussed, we'll be discussing understanding electronic signatures in South Africa. Let's dive right in. We know that navigating the world of real estate transactions can be complex, especially when it comes to understanding the legality of electronic signatures. In South Africa, the Electronic Communications and Transactions Act of 2002, known as the ECTA, governs the use of electronic signatures. However, when it comes to the sale of immovable property, the ECTA takes a backseat to the Alienation of Land Act of 1981, which is also known as the AoLA. So according to the Alienation of Land Act, a sale of land is only legally binding if it is documented in a written deed of alienation, which must be signed by the involved parties. This means that for the sale of land, electronic signatures are not valid. So there was a court case, it was held by the Johannesburg High Court, where it reinforced this case between Aarifah Security Services and Jakoita Properties, stating that electronic signatures cannot replace the statutory requirement of a physical signature on a deed of sale under the Alienation of Land Act. So what does this mean for buyers and sellers? Simply put, to ensure that a sale agreement is enforceable, all parties must sign a physical document. Any attempt to use an electronic signature for the sale of land will render the agreement invalid and non-binding. This is a crucial point to remember for anyone involved in real estate industry in South Africa to avoid any legal complications. So in summary, while electronic signatures are convenient and increasingly common in various transactions, they are not applicable in the sale of immovable property in South Africa. Always ensure that a traditional ink signature is used to keep the sale agreement valid and enforceable. Just something from our director, Elise van der Merwe at PropWiz. We ensure all property transactions comply with legal requirements. Though we are not legal advisors, we ensure to know, understand, and implement property law. So just in summary with regards to electronic signatures in the real estate transactions, electronic signatures are governed by the Electronic Communications and Transactions Act of 2002. The sale of immovable property is governed by the Alienation of Land Act of 1981, requiring a written deed of alienation signed by involved parties. What is the legal requirement? Electronic signatures are not valid for the sale of land. A physical signature is mandatory. So we discussed that there was a court ruling at the Johannesburg High Court, which confirms what we are discussing. And then the implication is we need to ensure that all parties sign a physical document to make the sale of agreement enforceable. So what should you do? Ensure compliance, use traditional ink signatures for real estate transactions, and the PropWiz commitment, we ensure all property transactions comply with legal requirements. Contact the PropWiz agent today if you are looking to sell or buy a property. Thank you for watching.